Hi, and welcome back. In these next 3 clips, I will address the topic of responsibility under international law. And like the topic of the law of treaties a few weeks ago, this might not strike us as immediately very exciting or very relevant, but in fact it really is. Determining which actor is at fault and what the consequences of this fault is at the heart and one of the most important questions within legal systems in general, and international law is no different in this regard. In this first clip, I'll provide a general overview of the law of responsibility, focusing in particular on the most important aspects regarding state responsibility. In the second clip, I'll remain with state responsibility, but will look more closely at the consequences that international responsibility entails, including countermeasures. And in the third video, we'll then shift our focus to non-state actors and their responsibility, as well as the topic of indirect responsibility that states might incur for the actions of non-state actors. Before we get to responsibility proper, it is useful to consider for a moment the two related concepts of accountability and liability. Accountability, on the one hand, is a broader term than responsibility, understood here as legal responsibility. And accountability might also include other mechanisms such as democratic or political accountability, which are not in fact a part of the legal framework of international law. Liability, on the other hand, relates to the existence of a financial obligation, meaning that it is a particular or more specific kind of responsibility that gives rise to financial monetary compensation claims. I'm flagging this aspect here because in international law we really talk about responsibility as opposed to the other two terms. Accountability and liability might re-emerge in some debates that are related to the discussions that we are having here, but really it is responsibility that is at stake, and you cannot use these terms synonymously when talking about the framework of international responsibility. I already mentioned the law of treaties as a kind of comparison, and another similarities between these two bodies of law, apart from the fact that they concern the more procedural secondary rules of international law, is that there is a core document that puts down most, if not all, of the important rules that we need to consider here. In the case of the law of treaties, that's of course the Vienna Convention on the Law of Treaties, and in the case of international responsibility, it's the articles on the responsibility of states for internationally wrongful acts, or in short ARSIWA, which were drafted by the International Law Commission over a longer period of time leading up to their adoption by the General Assembly in 2001. As a UN General Assembly resolution, they are not as such binding, of course, but they are considered to reflect customary international law and are therefore really central to this discussion that we are having here. What I do for the remainder of this first clip, and in fact the second clip, is to guide you through the articles, through ARSIWA. So I would therefore suggest you open the document and have a good look at the various provisions, see how they are formulated, and see what specifically they entail in terms of procedural norms. The most basic, but arguably also most important aspect of the law of state responsibility can be found in Article 2 of the ARSIWA, which states that there is an internationally wrongful act of a state when conduct consisting of an action or omission, A, is attributable to the state under international law, and B, constitutes a breach of an international obligation of the state. This introduces us to the foundational principles, or indeed requirements, of state responsibility, namely on the one hand attributability and on the other hand the existence of a breach of international law. The first aspect, attributability, is arguably new to us, but it is not particularly complicated as a concept. It basically means that a particular conduct should be attributable, meaning traceable or referable to a state in question, meaning in particular, as it's put under Article 4 of the ARSIWA, to the organs of a state. The notion of the organ of a state is relatively broad and includes any person or entity that, of course in accordance with the domestic law of the country, performs an executive, judicial or legislative or really other governmental function. And that can include the central government, but also the more territorial subunits, including, for example, provincial government or even municipal local authorities. In fact, Article 5 of the ARSIWA stretches this notion even further, to also include entities that, while not strictly speaking organs of the state, still perform what the ARSIWA calls elements of governmental authority. What comes to mind here are various private companies, whether they're involved in running prisons or social housing. The conduct of such entities, when unlawful under international law, can still bring about the international responsibility of a particular state. So, as Klabbers says, outsourcing these kinds of governmental tasks is not really an option to avoid international responsibility. Importantly, international responsibility comes about even if such an organ of the state acts in excess of its authority, meaning actually unlawfully under the domestic law that gives it its particular powers. What is important here is not so much whether the conduct was lawful from a domestic law point of view, but whether the entity acted in a public capacity. And here, of course, Klabbers discusses the example of a police officer doing something in his private, in his free time, which then would not actually fall within the scope of this particular provision. The second composite element of state responsibility will probably be more familiar to us because it refers to the existence of a breach of international law. Described further in chapter 3 of part 1 of the ARSIWA, we find elements here that we recognize immediately, such as, for example, a breach only existing if a state has priorly consented to be bound by an international legal obligation, pacta sunt servanda. The obligation should also have been in force at the time when the alleged breach occurred, and this is perhaps a new aspect and something that you should have addressed in your reading question, the intent of the state organ doesn't really matter. As Article 12 the ARSIWA points out, the origins and character of the breach are not really important. What is relevant is that there's been a material breach, that there is a visible and evident non-conformity with the obligation in question. Another aspect that I'll only briefly mention here is discussed in greater detail in chapter 4 of part 1, and that is the responsibility that a state could incur in connection with the acts of another state, meaning when they aid and assist a state that has actually breached an international legal obligation. Such aiding and assisting in a breach of international law can actually lead to a separate breach of international law, separate from the one of the state that has engaged in such a conduct. Of course, in this case, you need to show that there has again been a material contribution, a material aiding and assisting of this internationally wrongful behavior. The last aspect that I'd like to mention here relates to chapter 5 of part 1 of ARSIWA, dealing with circumstances precluding wrongfulness, meaning those specific situations in which there is no international legal responsibility, despite the fact that, in fact, both of the principles are met. Now, if we look at the provisions in this part, we will see once again a striking similarity to something that we saw in the law of treaties, namely those provisions relating to treaty invalidity. If you look more closely at this chapter, you will see that circumstances precluding wrongfulness include grounds such as force majeure, so the existence of an irresistible and unforeseen force, distress, necessity, but also self-defense. So basically conduct that is reasonable, but that still somehow breaches the international legal obligation in question. And in those specific situations, a state can legitimately claim that it should not be held responsible, even though there has been a material breach of the obligation in question. Article 22 finally mentions lawful countermeasures in response to an internationally wrongful act by another state party as another circumstance precluding wrongfulness. But this, of course, brings us to the question of the consequences of international responsibility, which I will bracket here and refer you to the next video, which I will in fact start with the discussion of countermeasures.